Now, $1 million question. Is preamble part of the Constitution or not? 1960, in Berubari Union case, Supreme Court said no. 1973, 24th April 1973 to be precise, in a landmark case, Keshavananda Bharati versus State of Kerala, the Supreme Court said preamble is part of the Indian Constitution. In 1960, in Berubari Union case, the Supreme Court thought that preamble is not the part of the Constitution. Because if preamble is like the preface to a book normally starts from chapter 1. So if book starts from chapter 1 onwards is the part of the book, preface is not part of the book. In the same manner, preamble, which is the preface to the Constitution, is not part of the Constitution. When it is not part of the Constitution, which means it cannot be amended. When it is not part of the Constitution, which means it is not having the same status as that of fundamental rights, directive principles, other provisions of the Constitution. But in the year 1973, Supreme Court was explained. Supreme Court was told, the dear Supreme Court, do you know how all these parts of the Constitution became part of it? All these parts, article by article, were discussed by the members of the Constituent Assembly. Then they were voted upon. And then once they were voted upon, they became part of the Constitution. So all the fundamental rights were discussed in the Constituent Assembly one by one, voted upon, and once they were voted upon, they became part of the Constitution. In the similar fashion, preamble was also discussed in the Constituent Assembly. Preamble was also voted upon in the Constituent Assembly. In fact, preamble was the last item added to the Constitution. Sir, but I have a confusion. I can understand your confusion. Sir, previously you said preamble is based on the Objectives Resolution of Pandit Jawaharlal Nehru, which was adopted by the Constituent Assembly on 22nd January 1947, and the Constitution was adopted on 26th November 1949. So how are you saying that the last item added to the Constitution was the preamble? Objectives Resolution is not preamble. Preamble is based on the Objectives Resolution. Preamble was also discussed in the Constituent Assembly. It was also voted upon in the Constituent Assembly. And it was the last item added to the Constitution. Why last? Because what is preamble? It's the philosophy of the Constitution. The Constituent Assembly wanted to ensure that whatever Constitution we have created, we have drafted, we have written, it should be consistent with the philosophy, which is the preamble. So that none of the parts mentioned in the Constitution, none of the provisions mentioned in the Constitution go against the philosophy of the Constitution mentioned in the preamble. So they wanted to ensure that the philosophy of the Constitution, which is the preamble, is in sync with all the provisions of the Constitution, with all the parts of the Constitution, with all the articles of the Constitution. And once they ensured, and the last item then was added to the Constitution, it was the preamble. So in this Keshavananda Bharati case, the Supreme Court was told, just like other parts of the Constitution, just like other articles of the Constitution, they were discussed by the Constituent Assembly, preamble was also discussed in the same fashion. Just like parts, articles by articles, clauses by clauses were added to the Constitution, when the members of the Constituent Assembly voted on these parts, voted on these articles, voted on these clauses, in the similar fashion, preamble was also voted upon. And in fact, it was the last item added to the Constitution. Hearing these arguments, Supreme Court said in Keshavananda Bharati case that yes, preamble is part of the Constitution. Now let's look at some of the quick points which can be relevant for your prelims examination. US Constitution was the first one to begin with the preamble. US Constitution also starts with preamble. It also starts with "We the people of the United States of America." In the similar fashion, our preamble also begins with "We the people." Second important point, preamble is part of the basic structure of Indian Constitution. This doctrine of basic structure we will discuss in Amendment to the Constitution, where we will discuss and analyze in great detail what was this landmark Keshavananda Bharati case versus State of Kerala of 1973. It was in this Keshavananda Bharati case that Supreme Court invented a doctrine called basic structure. Very briefly, can Parliament amend the Constitution? Yes. But there are some provisions in the Constitution which are very important, very basic, fundamental, and no amendment can remove these provisions from the Constitution. No parliamentary law, no executive action can violate basic structure of the Constitution. So can you make it even simpler? Let's say, for example, this is a building, or let's say this is a flat, let's say this is a room. In this room, can I change this stylus? I can. Can I change this writing pad? I can. Can I change the lights? I can. Can I change the camera? I can. Can I change the color of this room? I can. But can I change the foundation of this building? I can. But then if I change the foundation of this building, then I have to create another building. If I change the foundation, then this building will not remain the same. In a similar fashion, we have the Constitution. There are some things which you can change, just like lights, mic, camera, tablet, stylus, color. But there are some basic fundamental features of the Constitution which are like the foundation of the Constitution which you cannot change. And Supreme Court said there are some provisions in the Constitution which are part of the basic structure. That means no law of the Parliament can violate basic structure. No action of the executive can violate basic structure. One such feature is preamble. So when preamble talks about sovereign, socialist, secular, democratic republic, you cannot amend the Constitution and remove socialist, remove secular, remove democratic, remove republic, remove sovereign. You can't do that. You can't remove political justice, economic justice, social justice, liberty, equality, fraternity, dignity of an individual. All these natures of Indian state, all these objectives of the Constitution, they are part of the basic structure of the Indian Constitution, which no parliamentary law, which no action of the executive can violate. So if preamble is part of the basic structure, then how was 42nd Constitutional Amendment Act of 1976 enacted? Because it is this 42nd Constitutional Amendment Act which added the word socialist, which added the word secular, which added the word integrity of. You can add more features to the preamble, but you cannot delete the existing features that are mentioned in the preamble. Which basically means you can enrich the preamble. Enrich the preamble by introducing more natures, by introducing more objectives. But whatever objectives are there, whatever nature is already present, you cannot remove them, you cannot replace them, you cannot delete them. Because all of them are part of the basic structure of Indian Constitution. That's another important point. Two more important points. Preamble aids the legal interpretation of the Constitution where the language is found to be ambiguous. What do we mean by that? The year was 2017. There was a big controversy on Aadhaar. Aadhaar, which is a unique 12-digit identification number. Every resident of India, not just citizen, every resident of India, even foreigners can get Aadhaar. Whoever is staying in India for 6 months is a resident of India and you are eligible to enroll for Aadhaar. So Aadhaar is not a proof of citizenship. Aadhaar is only a proof of identity. Aadhaar proves X is X. That's it. Aadhaar is not a proof of citizenship because even foreigners can get Aadhaar. But there was a controversy on Aadhaar that it violates privacy. because you give iris scan as one of your biometric information. You give your fingerprint as one of your biometric information. So if I enroll for Aadhaar by giving my fingerprint, by giving my iris scan, it can be misused as well. Misused in the sense that through these biometrics, my life is as transparent to the state as contact lens. Through these biometric details, the state can create a surveillance mechanism. Surveillance mechanism in the sense, if this Aadhaar number is linked to various databases. For example, there is one database which talks about my bank accounts. There is another database which talks about my health record. There is another database which talks about my phone records, SIM. If SIM card is linked with Aadhaar, if my bank accounts are linked with Aadhaar, if my health records are linked with Aadhaar, then this Aadhaar in technical language becomes a primary key. And through this primary key, you can get every detail of an individual. Which means the government will come to know, who am I talking to? Which bank account I am using to book a travel ticket? Which means the government gets to know where am I traveling. Which means some people will get access to my health record as well. Which means you are creating a surveillance mechanism wherein the government can know exactly who are you speaking to, what are you speaking, where are you going, who are you meeting. Everything becomes known to the government. Which means we are creating a surveillance state. That's why Aadhaar was criticized. One former judge of Karnataka High Court, Justice K.S. Puttaswamy, he approached the Supreme Court, challenged the constitutional validity of Aadhaar on the ground saying that Aadhaar violates the right to privacy of individuals. But the government said, right to privacy is not a fundamental right. Where is it mentioned in the Constitution that right to privacy is a fundamental right? We have right to equality, we have right to freedom, we have right to life, we have freedom of speech and expression, we have right against untouchability, but where is right to privacy mentioned in the Constitution? A 9-judge bench of the Supreme Court was set up. 9 judges of the Supreme Court sat together to decide whether right to privacy is a fundamental right or not. Because there seems to be ambiguity. Because there is ambiguity. There is no clarity as to whether right to privacy is a fundamental right or not. In this situation, what does the Supreme Court do? What does the judiciary do? It takes a look at the preamble. Because what is preamble? It's the philosophy of the Constitution. The Supreme Court looked at the preamble. And by looking at the preamble, Supreme Court said that one of the objectives of the Constitution is that preamble says we have to ensure the dignity of an individual. This dignity cannot be ensured unless and until citizens have privacy. So if you want to ensure dignity of an individual, for that citizens should have privacy as well. Right to privacy is now a fundamental right according to 2017 judgment of the Supreme Court in K.S. Puttaswamy versus Union of India. So Supreme Court had to decide whether right to privacy is a fundamental right or not under Article 21 of the Constitution. Since there was ambiguity, since Article 21 did not explicitly talk about right to privacy, Supreme Court looked at the preamble. And in the preamble, Supreme Court said, one of the objectives of the Constitution is ensuring the dignity of an individual. This dignity cannot be ensured unless and until people have privacy. So right to privacy is a fundamental right. So preamble can be used to interpret the Constitution when the language is found to be ambiguous or not clear. This is the significance of the preamble. But preamble by itself is not enforceable in a court of law. What do we mean by this phrase that preamble is not enforceable in a court of law? For example, fundamental rights are enforceable in a court of law. Fundamental rights, which we will discuss subsequently. One such fundamental right is right against discrimination. I should not be discriminated against. Right to equality. Right to freedom of speech and expression. Let's say, for example, I have the fundamental right of freedom of speech and expression. I can say whatever I want to say. I can express whatever I want to express. I want to write a book. I want to write a song. I want to direct a play. I want to make a movie. What if this fundamental right is violated? I can directly approach the Supreme Court. And Supreme Court is the protector of my fundamental right. That means fundamental rights are enforceable in a court of law. Which means if your fundamental rights are violated, you can directly approach the court. And the court will protect your fundamental rights. But preamble is not enforceable in a court of law. Which means you cannot approach the Supreme Court and ask the Supreme Court that preamble is not implemented. Preamble is not followed. Preamble by itself is not enforceable in a court of law. Then you might ask, then what is the significance of preamble? Significance number one, it aids the legal interpretation of the Constitution when the language is found to be ambiguous. But then another significance. One of the objectives of the Constitution is political justice. And we ensure political justice through fundamental rights. And these fundamental rights are enforceable in a court of law. So even if preamble is not by itself enforceable in a court of law, but we have given effect to these objectives through fundamental rights. And fundamental rights are enforceable in a court of law. Preamble is the philosophy of the Constitution. Preamble is the identity card of the Constitution. Preamble unlocks the minds of those who framed our Constitution. Preamble itself is not enforceable in a court of law. But the other Constitution, the remaining Constitution, is enforceable in a court of law. So the significance of preamble is that it aids in the legal interpretation of the Constitution when the language is found to be ambiguous. This completes our discussion on preamble. So what is preamble? Preamble is the philosophy of the Constitution, is the identity card of the Constitution. And when we look at the text of the preamble, we can break it down into 4 themes. We the people of India, which means the source of authority of the Constitution is the people of this country. Theme number 2, what is the nature of the Indian state? Sovereign, socialist, secular, democratic republic. Theme number 3, what are the objectives of the Constitution? Justice, social, economic, political, liberty, equality, fraternity, dignity. And it is through this dignity that we can ensure the unity, integrity of this nation. And the 4th theme is, preamble tells us about the date on which the Constitution was adopted. But in subsequent chapters, we will revisit preamble again. And we will try and understand, is there a clash between what is mentioned in the preamble and what is the empirical reality? If the preamble talks about liberty of thought, why is it that there is repeated violation of freedom of speech and expression? If preamble says one of the objective is liberty of worship, why is it that there is a controversy on hijab? There is a controversy on halal food. There's a controversy on religious matters. If the objective of the Constitution, as mentioned in the preamble, is ensuring fraternity, is ensuring a sense of commonhood? Why do we hear speeches which are trying to create a wedge between different communities in India? And how do we tackle them? If the preamble talks about socialism, why is it that the gulf between rich and the poor is not minimizing, but widening day by day? Why is it that a report by Oxfam, it says 1% of the people of this country control the wealth, which is up to 99%. 99% of wealth of this country is controlled by 1% people. If the preamble talks about justice, why do we still see injustices being meted out to members of the Dalit community? If the preamble talks about justice and political sphere, why do we see political inequality as well? Is preamble still relevant in India or not? All these questions we will answer, we will try and address in the subsequent lectures. So keep watching these lectures, you will find answers to all these questions. This was Preamble to the Indian Constitution.